Obviously, because for all of us watching on today, we don't have a skin in the game. You do. This is your bill. You are a private member who sponsored it. And so when you saw what happened today, I know you weren't in court. I wonder what was your immediate reaction when you first realized that it was open for public, coverage, media coverage, allowing cameras in there. And also, the happenings in the court today was exciting. For us mere mortals who aren't lawyers, it was great to see the Chief Justice and Tadio Sore, your good friend, sparring, and not a substance so much as to the form of what we saw today. I don't know what your own reactions were.
First of all, thank you for the opportunity to join you. And good evening to my professor, Professor Apiaje Chia, and then our other co-panelists and our viewers. First of all, I'm happy that the court permitted live coverage because it reduces the pollution of the reportage from the court by persons who are not well versed in the matters of procedural law before the court. So to that extent, it was good. Second, my worry is that this matter is being heard under an express application by the Speaker of Parliament through his lawyers for an expeditious hearing. And like I said earlier on today, I am comparing the time that it took the court to fix this matter for hearing today, between today and when the letter actually came, and that's about 6 weeks. But if you compare that to the way they treated the request by the Attorney General to have my matter, which also has an impact on Parliament and its work, it took, I believe, within 3 days, for the matter to be, for the court to be empaneled and the matter heard. So, but let the record reflect that these are all the motions. It's not in respect of the substantive matter before the court.
Yeah.
The court is only spending this time to deal with the interim and interlocutory applications before them. Now, being a matter that is heard on an application for expeditious hearing, the practice of the court is that the matters are not adjourned sine die. The matters are ordinarily adjourned to a definitive date, within which the parties, if they have any processes to file, are given time to then file them. So, for instance, if this matter were adjourned to, say, 30th May, then the court could direct that plaintiff, if you have any process to file, you file it 4 days after today's adjournment. Then the court will then direct the defendants that when the plaintiff files these processes and you are served upon service, you have 4 days within that time to also file your process. So, plus or minus, within 8 days after today's adjournment, all parties in the matter that have anything to file, any additional process to file, would have done so. So when this matter is called again on 30th of May, if this were the case, then the court would have been properly constituted and ready to deal with the merits of the application.
Yeah, but